So, we'll discuss question number 3. Describe the different modes of creation of agency and as it is provided under section 186 and 187 of the Indian Contract Act, so also with illustrations. So, the very creation of agency as provided and the following acts by express authority, by implied authority, and that implied authority by estoppel and holding out, and by presumed agency, and number 3 by ratification, and number 4 by agency of necessity. So, as provided under section 186, the object of the creation of the agency is to arm the agent with necessary authority. The authority of an agent may be express or implied, and as provided under section 187, the authority is said to be expressed when it is given by words spoken or written. Authority is said to be implied when it is to be inferred from the circumstances, things spoken or written in the ordinary course of dealing may be accounted from circumstances of the case. So, the very illustrations as we like to discuss, the illustration that is a owns a shop in Srirampur, living himself in Calcutta and visiting the shop occasionally. The shop is managed by B and he is in the habit of ordering goods from C in the name of A for the purposes of the shop and for paying them out of A's fund with A's knowledge. B has an implied authority from A to order goods from C in the name of A for the purposes of the shop. So, creation by express authority. So, normally the authority given by a principal to his agent is express authority enabling the latter to bind the principal by acts done within the scope of that authority. No particular form is required for appointing an agent, but in certain cases, formal documents are essential. For example, in order to authorize a person to effect the convenience of landed property, there should be a power of attorney, which is a formal deed of appointment drawn up and signed by the principal. An advocate can only be appointed by executing a vakalatnama. An authority to execute a deed must be given by a deed. And as regarding creation by implied authority, the conduct of the principal may create an inference that an authority has been conferred upon an agent, even though no authority was ever given. In fact, in such a case, if the agent contracts within the limits of his ostensible authority, although outside the limits of his actual authority, the principal will be bound to third parties by his agents act, and this may happen in two ways. Why the application of estoppel and holding out, or by a presumption in cases of cohabitation. So, why application of estoppel and holding out, where a person permits or represents another to act on his behalf, so that a responsible, reasonable man would infer that the relationship of principal and agent has been created. He will not be permitted to relieve himself of his obligations to a third party by proving that no such relationship in fact existed. A person who delivers goods to a mercantile agent is presumed to have authorized by any sale, placed, or other transaction of the goods by the agent when acting in the ordinary course of business. A partner who retires from a partnership must give notice of his retirement, otherwise he will continue to be liable under this principle. So, now we'll go to liability of principal, inducing belief that the agent's unauthorized acts were authorized, and in relation to that the illustration. So, when an agent has without authority done acts or incurred obligations to third person on behalf of his principal, the principal is bound by such acts or obligations if he has, by his words or conduct, induced such third person to believe that such acts and obligations were within the scope of the agent's authority. And the very illustration relating to this is a, a consigns goods to be for sale and gives him instruction not to sell under a fixed price, seeming ignorant of this instruction, enters into a contract with B to buy the goods at a price lower than the resort price. A is bound by the contract. And in another illustration, A entrusts B with negotiable instrument endorsed in bank. B sells them to C in violation of private order from A. This sale is good. And by presumption, the creation of agency, and that is when a man and woman are living together as husband and wife, there is a presumption that the wife is entitled to place his credit for necessaries which are suitable to his style of living and which fall within the domestic departments usually assigned to the wife. And as it was decided in the leading case Divan versus Mellon in 1880 by the Court of Appeal, so also in another leading case, that is Ryan versus Sams in 1848, the Queen's Bench held that the presumption arises from the act of cohabitation. Hence, it is extended to a mistress living together with her lover. And the next one, that is why ratification, the creation of agency with illustration, where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts, where a purpose to act as agent for B either having no authority at all or having no authority to do that particular act. The subsequent ratification by B of A's act has the same legal consequences as if B had originally authorized the act. It is therefore said that the effect of ratification would be that the agency would relate back to the date of the transaction made by the agent. Thus, an unauthorized act is converted into authorized one by conferring authority subsequent to the act. Hence, it is known as agency by ratification. And the last one, that is agency of necessity, as it is a factor of creation of agency. Generally, the authority given by a principal to his agent in an express authority, enabling the latter to bind the former by act done within the scope of that authority. But in certain circumstances, the law confers an authority in one person to act as an agent for another without requiring the consent of the principal. Such an agency is called an agency of necessity. When one person is faced with an emergency in which the property or interest of another are in imminent danger, and it becomes necessary in order to preserve the property or interest to act before the owner's instructions are obtained, the law assumes consent of the owner to the creation of the relationship of principal and agent, or to the extension of existing authority to the act done in the emergency. So these are the four different factors or modes of creation of agency as provided under section 186 and section 187 of the Indian Contract Act 1872, and those modes are by express authority, by implied authority, and that implied authority is of three different types: by the application of estoppel and holding out, and the second one, liability of principal, inducing the belief that agents unauthorized acts were authorized, and the third by presumption, and the number three modes of creation of agency by ratification, and the number 4, creation of an agency. The mode is agency of necessity. So these are the appropriate answers relating to question number 3, which asks describe the different modes of creation of an agency.